Pregnancy Discrimination Act. It's a federal law in the United States that's designed to protect women who are pregnant. But in real life, how does it work? Well, that takes us to this week's case. Involves Rule 1. She was working for UPS as a driver. As a driver, she had to fulfill the requirement that she lift up to 70 pounds. Well, when she got pregnant, she said to UPS, I can't really lift 70 pounds anymore. It's really not healthful. Therefore, I'm asking for a light-duty job. UPS said, no, we're not going to give you a light-duty job. Because under the deal we have with the union, we only provide light-duty jobs to people who are injured in the course and scope of employment while they're on the job, or to people who meet the definitions under the Americans with Disabilities Act. Pregnancy doesn't meet the definitions. You, therefore, do not get special accommodation. You, therefore, don't get a light-duty job. Well, she had to then take an extended leave of absence during her pregnancy, and following all of this, she sued. She sued UPS and said, guys, the Pregnancy Discrimination Act under federal law is designed to prevent discrimination against women. I'm being discriminated against. I'm being discriminated against because I can do other work, but you're not allowing me to do other work because I'm pregnant, and therefore you're discriminating against me. UPS, on the other side of it, argued, well, you know what? In this instance, we're not discriminating. You are working as a truck driver. One of the requirements of that job is you had to lift 70 pounds, and we also pointed out that in terms of light duty, that's only available to people who were hurt on the job or people who met the definition under the Americans with Disabilities Act. And in short, hey, we're not treating you any differently than we're treating any other worker. If some guy had been out there water skiing and suffered a back injury and couldn't lift 70 pounds, he would not get a light-duty job. So, hey, we aren't going to give you a light-duty job. Well, woman wasn't pleased. So she brought suit, went to federal court, and then it went up to the 4th District Court of Appeals. And there, the court looked at this, listened to the various arguments that we've just heard presented here, and they came away with the decision that said, guess what? UPS, you're right, guys, because at this point in time, we find this conduct by UPS to be a neutral conduct. It isn't discriminating against somebody who is pregnant. In this instance, she was asking for a change in job duties. You did not in any way prohibit her from continuing in her job. It's that the requirements of the job could not be fulfilled, and therefore she needed to take a leave of absence. That was not discrimination. That was simply enforcing the job requirements which existed prior to her pregnancy, during her pregnancy. And when she was unable to continue to perform them, well, she could take a leave of absence. All right. So what do we learn from this case? Very simple things. Sometimes some statute may appear on the surface of it to provide certain rights that in reality are not there when applied to a specific situation. And here what the court said, as I've already pointed out, was something very simple. This woman was treated in the same manner as any driver would be treated. The fact that her pregnancy prevented her from doing the job did not require that UPS give her a different job other than a truck driver. All right, hey, we bring you this case, as we bring you cases every week, so you understand how the law works. I'm David Allen.